So, applications to strike in terms of Rule 70, an applicant or a party is also entitled to apply for things to be struck out from an affidavit. That's Rule 70, Sub-Rule 4, which says that the court may, on application made to it, order to be struck out from an affidavit any matter which is scandalous, vexatious, or irrelevant, with an appropriate order as to costs, including costs on the scale as between legal practitioner and client, but the court may not grant the application unless it is satisfied that the applicant will be prejudiced in his case if it is not granted. So there's two things that the applicant will have to come and do. The applicant in an application to strike must first of all satisfy the court that it's whatever matter they want struck out meets those three things. It's either scandalous, vexatious, or irrelevant. But they must also show to the court that if this matter is not struck out, they are going to be prejudiced in their case, in how they conduct their case, or move their case, or defend, or whatever. So there's a nice case which deals with most of these issues, and that is the case of Vaghte versus the Law Society of Namibia. The reference is there. It's 1990 volume. Can everybody see that? Read that. Okay. 1990 volume. Sorry, it's not. There's no other volume. It's 1990 NR 332. You will notice that Mr. Vaghte has really contributed quite a bit to our jurisprudence. He even took me along once. Okay. So in this case, basically, as you can see, what Mr. Vaghte was trying to do, the case was about granting the public access to disciplinary hearings. There was a disciplinary hearing against Mr. Vaghte, and he wanted members of the public to be granted access to this disciplinary hearing of his. And he was relying on the Constitution and all of that, and as spirited as he is, he in his affidavit that he brought to court, he made quite a few very compassionate statements, which in most cases had nothing to do with the case itself. So when you are considering an application to strike, you need to, for instance, with the issue of whether or not something is relevant, you need to be able to determine what is the issue that is before me. What is it that I need to determine? And are these allegations that the person is making, are they necessary for purposes of determining this case? So the first thing that you have to figure out for yourself is, what is the case about? What are the issues? And what must I, at the end of the day, determine in order for the applicant to succeed or the respondent to succeed? So those, that's your starting point. So what I've done is I've taken some of the allegations that he made in his affidavit, just to illustrate these points. So allegations which may or may not be relevant, but which are so worded as to be abusive or defamatory, though that is what scandalous means. So they could be relevant to the proceedings in terms of they assist in the determination of the issues before the court, and they could also not be relevant. They could just be made for the fact of just the person is just filling the space or whatever it is they're trying to do. But the import of the words are abusive or defamatory. So what he was then saying here, he was referring to the rules of the Law Society, and then he said, these rules are designed to ensure that high fees are earned by the profession at all times, and that competition is reduced to a minimum, thus ensuring that established firms can maintain their high rate of income. Now, I'm wondering whether today still this would be considered defamatory.
I wonder.
Considering that there's a competition law in place. But he could have probably put it better. But the point is, this had absolutely nothing to do with what he came to court for. He wanted the public to be granted access to a disciplinary hearing. So the question is, what does that have to do with anything? Okay, so first of all, it's irrelevant to start off with. But it's also clearly aimed at defaming the Law Society and its members, and it is abusive. That's what the judge said. So that's what a good illustration of what scandalous means. So here's what the comment that the judge said. These words need only be quoted to be categorized as scandalous, and if allowed to stand, will obviously be prejudicial to the respondent's case. A reply by respondent could sidetrack the case in issue. The legal profession is a noble profession existing since time immemorial. It boasts a tradition of independence, honesty, and service to the public. The respondent is the custodian of those traditions and has developed its rules, to ensure the perpetuation of those traditions. Obviously, rules can be amended and adapted to changing conditions, and should any member of the respondent believe that the rules should be amended, channels exist in the constitution of respondent to effect those changes. So if he's unhappy with what the court is saying, if he's unhappy, he should make use of the normal processes. This court case was not the forum for him to have dealt with his gripe with regards to rules. Okay. Does everybody understand what scandalous means? Okay. Then he says, Mr. Vaghte continues, and he says, the public should know the steps taken by respondent to accuse and then punish its members, and in that manner gag its members. By these allegations, applicant insinuates, this is what the court's response was to this, that he will not receive a fair hearing and that he will be found guilty of the charges brought against him. He will be accused and then punished. Applicant overlooks the fact that there is a right of appeal to the High Court from a decision of the tribunal before which he is to appear. But in any event, his allegation that the tribunal before which he is to appear is biased, and the fact that he has prejudged the issues is scandalous. If you look at the act, the disciplinary committee actually falls under the Ministry of Justice. It is constituted by members of the public. So he was not members of the public, members of the Law Society. But the point is, it's actually falls under the Ministry of Justice. So it doesn't fall under the direction or control of the Law Society itself, except for the fact that it's the members of the Law Society that are sitting on the disciplinary committee. The Act also says then, if you're unhappy with that decision, you can obviously challenge that decision by way of court proceedings. But now, what Mr. Vaghte is now saying is that he's not going to get a fair hearing anyway. The whole idea is just to keep him quiet. So that, the court also said, was scandalous. Now, if the Law Society was to have to deal with these allegations in its answering papers, in response to an application to allow the members of the public to attend a disciplinary hearing, it's going to be a waste of time of the court as well as the respondent. It will increase costs, and that is not what the court wants. Okay, so those allegations were then struck. Vexatious allegations are allegations which may or may not be relevant but are so worded as to convey an intention to harass or annoy. To illustrate this, let's look at what Mr. Vaghte said. It is a daunting experience for me to realize that respondent and those in charge of it can think of nothing better but to put their knife into my back. The court's response, this terminology has absolutely no place in an application of this nature. The phrase, to put one's knife into someone's back, is scandalous and conveys an innuendo of improper conduct by a respondent. Furthermore, it also has the innuendo that respondent is biased and prejudiced against applicant. This is calculated to prejudice respondent in this case before this court and is accordingly struck out. So it calls it scandalous as well, but in actual fact it's also vexatious. It's really just there to annoy or harass the respondent. Yes. I think this is coming from the court. An argument justifying the right of the public to be entitled to be present could have been advanced in measured and respectful terms. The principle to which he refers did not have to be clothed in offensive language. The conclusion is that applicant intended to prejudice respondent is inescapable. Objectively, in any event, it clearly does prejudice the respondent. So he just wanted to make the respondent look bad in the eyes of the court, and it wasn't necessary, is what the court is saying. Irrelevant allegations are allegations which do not apply to the matter at hand and do not contribute one way or the other to a decision of such matter. So all the others that I've read now, the ones that I've illustrated just now, used to illustrate scandalous and vexatious matter, are also irrelevant, because if you look at the issues between the parties, it had no bearing on what was before the court. It didn't help the court in arriving at its decision. So the whole purpose of the affidavits that the parties file is to help the court to make a decision on the issue or the dispute that is between the parties. So making those allegations took the court nowhere, in actual fact. Okay. So then, even if this is a comment that the court made, and this is in relation to what I've already referred to, even if they should be true, they do not relate to and have no bearing on the ultimate question, namely whether or not respondent is entitled to hear in camera an inquiry as to whether applicant has acted unprofessionally. So none of those conditions, none of those allegations that he has made assists the court in making a call on this issue before it. Okay. So now we go to the prejudice issue. So a lot of the time people will make a whole lot of irrelevant allegations in an affidavit, and it might not really be, it's not necessarily scandalous or vexatious or in that sense harmful to the other party. But it's irrelevant to the proceedings, and the question that the court will look at, doesn't matter which one of the three it is whether or not the respondent or the applicant, the person who's applying for the striking out, will be prejudiced if those allegations were to remain. So in this case, what the court said is the striking out procedure was not intended to be utilized to make technical objections of no advantage to anyone and just increase costs. Obviously, an application to strike, especially when it is heard on its own, will increase costs, add to court time that is not necessary. And so if there is no prejudice to the person who's bringing the application to strike, then there is no need for the court to go into this. So whoever wants matter to be struck from an affidavit has to show the court that they will be prejudiced in some way in their case. So one of the ways in which you show prejudice is if there's all these unnecessary allegations which are only there for for purpose other than to advance the case that the person is making, that person will have to answer to those allegations, because if they don't answer them, they might be prejudiced if the court considers those allegations. So that respondent will have to draw up answers to allegations. It becomes tedious, it's lengthy answers, may have to bring other evidence just to deal with those particular allegations. And what does it actually do? It doesn't take the court anywhere, especially where the allegations are not only vexatious or scandalous, but they are also irrelevant to the proceedings before the court. It inflates costs, which is not necessary. So it will normally be part of another application. You won't bring an application to strike what is usually, well, it's always part of another application, or in action proceedings it will be part of that proceeding. So there will be other affidavits and things. Those are the affidavits that you'll be attacking with your application to strike. So yes, there are costs involved. The point is, say for instance, these allegations are made in the applicant's papers. So now the respondent needs to answer to these allegations. First of like things, also hearsay. The court can ignore it, but you can also apply for hearsay to be struck because it's irrelevant. It's not assisting the court because the court need not consider it because it's not reliable evidence. But now, if you don't deal with it, if you don't strike it out, and the court is not alert to the fact that it's actually hearsay, you could be prejudiced because then unreliable evidence will be used against you, which should, with research and all of that, the time that you spend on dealing with an irrelevant issue, it's wasted time and money, and who's going to bear those costs? So that's the prejudice that arises when you are dealing with matter which is either irrelevant or scandalous or vexatious. Okay. This, I believe, it also comes from the Farts and the versus Law Society matter. The phrase prejudice to the applicant's case clearly does not mean that if the offending allegations remain, the innocent party's chances of success will be reduced. It is substantially less than that. How much less depends on all the circumstances. For instance, in motion proceedings, it is necessary to answer the other party's allegations, and a party does not do so at his own risk. If a party is required to deal with scandalous or irrelevant matter, the main issue could be sidetracked, but if such matter is left unanswered, the innocent party may well be defamed. The retention of such matter would therefore be prejudicial to the innocent party. So it's not always necessarily a question of whether or not you could lose or win the case or whatever. It's about the costs that are involved, the issues are sidetracked, and you could be defamed. These things stand, remember, they stay on those papers and the whole world can see it. And if you don't deal with it in your replying affidavit or whatever you are dealing with, answering affidavit, then what is the perception that will be created in the minds of the person who reads it? So if an allegation such as that is made, you don't deal with it because you think it's irrelevant and the court doesn't strike it out, somebody comes and gets these papers and reads it, what is the perception? Oh, he didn't deny it. He didn't give proof that he's not doing this. Then that person is defamed. Okay. So the person might make out a case. Remember, it's not going to be the whole affidavit that you'll strike out. So it's particular. When the person is applying for a strikeout, they have to mention the specific allegations that they want struck out. They cannot just say, state it in general. They actually have to refer to the specific allegation. I think I have an example of that here, if I'm not wrong. So this is an example of an application to strike. So you'll see here, in the application, the applicant was specifically mentioned. So here there were specific paragraphs in the affidavit that were found to either contain irrelevant, vexatious, or scandalous matter, or constituted argument or inadmissible hearsay evidence. So those paragraphs, 10, 13, 15, 18, 20, 34, those ones were sought to be struck out. Then you see here in paragraph 45, it was only a part of the paragraph that was sought to be struck out. And this was considered to be argumentative or matter of argument. See, in your affidavits, you're not supposed to raise legal arguments. You're supposed to deal with your facts and your evidence. Okay. In 46, the strikeout was restricted to certain words or a certain part of the paragraph only. So this was also an argumentative paragraph. And this part, if you look at this part here, this can also be considered to be vexatious or scandalous. In 58, we were talking about the whole paragraph. So you see, it's not the whole, you just don't make a general statement. You actually refer to specific paragraphs or sentences in a paragraph that you say should be struck out. Now, why does the court not just dismiss the application? Because it might be that even with those allegations being struck out, the person makes out a case, actually, at the end of the day, which actually shows you that those things that they said was totally irrelevant. They didn't need to say it. And it was really just there either to embarrass the other party, to defame the other party, just to make the other party look bad in the eyes of the court, which was not necessary because you actually have a good case otherwise anyway. So then that normally illustrates to the court that this is actually an appropriate case for you to have struck out the allegations. Because you could have said it said it in a much better way, or you could have succeeded with your case without saying it. Then why did you say it? What was your motive? What were you trying to achieve? And is that prejudicial to the other party? What if the court makes a mistake on that? Or what if the court doesn't pick up on that? What if the court just reads through the stuff and just takes everything as is? And what if the court is influenced by those defamatory allegations against the other? The judge is just a person. He's just a human being, just like anybody else. And it's unfortunately so that we are also guided by our own prejudices that we grew up with or whatever, the societies that we live in. So you can easily manipulate a judge if you want to. And I'm not saying that the judges are, okay, no, let me not say easily. You can manipulate a judge into a certain direction. And this is why I'm saying it's sidetracking the real issue. And it has happened that because of people have actually lost cases, and sometimes it's actually to your benefit for those things to be struck out, because it actually, at the end of the day, it could sidetrack the court so much from the real issue that the court doesn't even look at the good case that you, as the part applicant or whoever else, has made, because they've been bogged down so much by all these terrible things that you've said that they totally forget about the case that you are trying to make here. And it could have been a very, very valid case. So it might even be to the benefit of the applicant sometimes for such allegations to be struck out instead of standing there. In having to deal with this, this is the thing. If somebody makes a defamatory statement about you in an affidavit, it's there for the whole world to see. Some cases are prominent cases. They are reported about, people report on them. Now, if you don't respond to those allegations, and you don't apply for them to be struck out, or you don't say anything about them, the public out there, when they read it, it says this person said so the reporter comes and says that person A said this about person B. Person B didn't deny it at all, or didn't deal with that allegation. What is the public going to do? That's how defamation works. It's going to become the truth.
But there's a remedy for that. You can sue for defamation.
Yeah, but why should you have to be put through a trial of defamation if it could be struck out? So practically, how it happens is that it would normally be dealt with at the same time as the main application. So the application to strike out will be argued. The court will not, at that point in time, necessarily give a ruling or an order or whatever. It could, and then hear merits on the same day. Or it can just continue to hear the merits of the application, and when it gives its judgment, it will deal with both the application to strike out and the application, the main application itself. So what the court will then do for itself is it will then decide, what am I striking out? then look at what remains and then base its decision on the merits based on whatever remains after the striking out. I believe that is also what happened in the Vaghte matter. So you can't amend an affidavit, right? No, you can't amend an affidavit. You can only correct it afterwards with another affidavit by, say for instance, you say something in your founding affidavit and you realize afterwards that you made a mistake with what you said there. You can, in your replying affidavit, you can refer back and say in paragraph so-and-so, I said A, B, C, and D, and actually it should just be A, B, C. So that's how you deal with mistakes that you've made. So it's not like in action proceedings where you can file a notice to amend. The only thing you can amend in an application is a notice of motion. But affidavits you can't amend. It's all about efficiency for the judges and also the time you spend on one matter. So yes, you can. The parties can ask the judge to deal with the application to strike separately, and that the parties would normally propose in their case management report. So I believe in the case management report, it makes provision for how preliminary issues or points in limine or whatever can be dealt with. Also in Rule 70, the court can give directions as to how any interlocutory application should be dealt with. So the parties can ask, they can agree, or the one who brings the application to strike can go to court and ask for the court to say, I want the application to strike to be heard separately because it might have a significant impact on the application itself, which might make it unnecessary for us at the end of the day to actually, argue the merits or argue the merits fully or whatever. So that can be done. So it's all within the discretion of the court as to how it wants to deal with this matter. That's the beauty of case management. And I suppose if the application to strike is quite significant to the extent that it will do away with most of what's in the affidavit and will leave a very skeleton case which might not make out a cause of action, then the court might actually deal with the application to strike in advance. But you would not normally have that kind of a situation, no. One would hope not. You can actually order the party who has made those allegations to pay the costs of the application because of the way in which he handled the matter.
Even if he's the applicant.
Even if he's the applicant, even if he succeeds in the case, you can order him to pay the costs, or you can order that there will be no order as to costs. Yeah. So the court then expressing its displeasure at how you dealt with the matter. I know of cases where I believe personally, in my personal opinion, that the person actually lost, not because he didn't have a good case, but because of these things that the person stated in the application or affidavits. I believe that the person should have won the case, they had a good case, but they really, really sidetracked the court with these very defamatory allegations that they made in the papers. So that could happen very well. So for a party, it's also very dangerous to do that because you can actually shoot yourself in the foot by doing so. Okay. So here's a cost issue. I think this was still in the Vaghte matter. It will therefore be seen that the application to strike out succeeds substantially in respect of both allegations and annexes. Respondent asks for attorney and client costs on the ground that the applicant has abused the process of the court. It is true that applicant has used strong language in that he has made scandalous vexations and irrelevant allegations, which have been struck out in that they are prejudicial to the respondent's case, but it cannot be said that he has abused the process of the court. The application for attorney and client costs is therefore refused, and the respondent is awarded its costs on the ordinary scale. Now, this was another matter. I believe in the Vaghte matter, in the High Court, there was actually a cost for attorney-client, an order for costs attorney-client. Let's just look at it quickly. In this case, Mr. Vaghte, again, what he was going for was the name change to streets, where one street where he lives and the other street where, another street in Ludwigsdorf or Kleinwindhoek or something. So he had a problem with the street being named after the minister, Itana's husband. And he made some allegations, but he made allegations regarding Minister Itana, who had nothing to do with his naming or anything. I think he said something about when he was on the Law Reform and Development Commission, nothing happened, pretty much said that, she was quite useless as far as that is concerned. So it had absolutely nothing to do with this case, because the question as to whether a street should be renamed after somebody else has to do with that person and what they have contributed to the country and that kind of thing. It did deal with her husband's contribution somewhat and said, I don't know of anything that he has done for the country and so on and so forth, but his attack was on Mrs. Itana, Minister Itana. So in the High Court, the court awarded attorney-client costs, and this is what the judge in the Supreme Court said, basically, and said that he agrees that it should have been awarded on that scale. And lawyers should also be very careful, because they could also sometimes be in the firing line. You've had cases where they, because of letters or things that they drafted, they were found to have acted in the same way, and they were then ordered to pay the bonus proprius costs. Okay, so in this case, that is the order that the court made, that the High Court's costs should still remain on an attorney-client scale. Okay. There are other objectionable matter which can also be struck out, and it's things like speculative allegations, argumentative allegations. Here we are still busy with costs, sorry. Yeah. Justifying an order of costs on a scale of attorney-client. But they are argumentative matter, although it's not mentioned in the rule itself, they can also form the subject matter of an application to strike out. So remember I gave you I showed you just now the example of an application to strike out where legal arguments were contained in the affidavit, which in respect of which an application to strike out was sought. This case, I think we also referred to in another context earlier, yesterday. Okay, so other objectionable matter is new matter in replying affidavits. You can also apply for those to be struck out, because if they stand, you are prejudiced because you don't have an opportunity to respond to it, and it's not an answer to say that, but the person could ask to file a further affidavit. That is not the intention, or that is not what should ordinarily happen. So you can't put new matter in a replying affidavit and then say, oh, but he could ask to file a further affidavit and deal with those allegations. That's not how it works. Allegations that touch upon or attack the credibility of a party, these are also considered to be irrelevant. So you can show that the person is being dishonest or not credible by giving facts or producing facts in your affidavit that shows that what the other party is saying is not true. But to then come out and say things like he's lying and that kind of stuff, it's not necessary. It's a conclusion that the court can draw from what you have already said. So that is not relevant. It's irrelevant because something that the court should do. It's for the court to decide whether or not the person is being honest or not, is being a credible witness or is not a credible witness. It's not for another party to come and say that. Another example of what we dealt with already earlier on yesterday in terms of what needs to be in a replying affidavit, and also about making your case in your founding papers as opposed to in your replying affidavit, and raising new grounds in your replying papers. It's not permissible, and so they can be struck because it will prejudice the other party. And there's the Swissboro case to just illustrate once again what is the purpose of affidavits. The applicant must make his case in the founding papers, and yes, in exceptional circumstances, the court can allow new matter in replying papers, but it would normally be because of what is said in the answering affidavit. Perhaps the applicant could not have foreseen that something like that would come up, and it would be obviously the court will have to be able to determine that from the affidavits as a whole, and in those circumstances the court might allow this new matter to be raised in replying affidavits. But what would probably also follow is that the other party would be allowed to file a further affidavit to deal with that, because otherwise it will be to the prejudice of the other party as well. Okay, so on this topic, I'm done with applications to strike out. Okay, then I will move on now to urgent applications. Those are dealt with in Rule 73 of your rules. So, at the High Court, basically you will have a judge every week who's on duty to hear urgent matters. And there's one who hears urgent matters during the day, and there's another one who hears urgent matters after hours, which gives you the idea that an urgent matter can be brought at any time, depending on the urgency of the matter. But the rule says that it should be heard at 9 o'clock on a court day, unless the legal practitioner certifies that the matter is so urgent that it must be heard at another time or on another day. So there have been urgent applications that have been heard on a Friday night. You've had urgent applications heard on a Saturday, on a Sunday. So anytime an urgent application can be heard, but the court must be satisfied that it is so urgent that it must be heard at that time and on that day. Okay. So there are two requirements that must be met by an applicant. When they bring an urgent application, they must set out the circumstances which he or she avers renders the matter urgent. That must be done in the affidavit. And they must give reasons why they claim that they could not be afforded substantial redress at a hearing in due course. A hearing in due course simply means if they were to come in the ordinary course with a normal application or an action proceeding, why would those proceedings not also afford them adequate or substantial redress? Okay. So all of this must be put in the affidavit. The way it looks, the application comes together with a certificate that has to be signed by the legal practitioner saying that the matter is urgent, and it is so urgent for it to be dealt with at the time and date, on the same date as is proposed in the notice of motion, and as provided for in the rule. So there is that certificate. The lawyer signs this, the legal practitioner, or the advocate, or whoever. And if you don't have that certificate, then you'll have a problem. Although these days, you will find a lot of applications that are not so urgent, or that are not urgent at all, but the certificate was signed anyway. So the court cannot just rely on that certificate. That's what I'm trying to say. You have to look at what is being raised in the papers to determine whether it is urgent. Okay, I've already dealt with these. What are the allegations that the party must make? This is in addition to obviously dealing with the merits of the matter. Okay. So the court can, it has, after listening to the evidence, it can strike the matter for lack of urgency, which means it would not have heard the merits or have considered the merits of the application. And the applicant, if he wants to continue with the application on the merits, must set it down in the normal course as a normal opposed application, and then the rules will then determine all the other things that needs to happen in terms of filing of answering papers, etc. So the parties, usually in practice, you would have the respondent either coming to court, depending on how much notice they have received of the application. They come to court either by way of affidavit dealing with the issue of urgency only, because they didn't have enough time to deal with the merits of the application, or they will deal with the urgency as well as the merits. But obviously, because of the limited time, you must accept that they wouldn't have been in a position to deal with them properly. Depending on, sometimes the application is not brought in like 1 day, 2 hours, or 2 days notice or whatever. Sometimes you actually get 2 weeks notice or weeks notice. It all depends on the urgency of the matter. Okay. So if the court dismisses or strikes the application for lack of urgency, obviously the respondent can then make use of the opportunity to file a proper answering affidavit as well. So the process just continues as it would under a normal application. If the court decides to hear the matter as a matter of urgency, then it then obviously has to consider the merits of the application and then decide whether it grants the application or not. So you can succeed on urgency, and then you can lose the application on the merits. It happens. You can lose the urgent application in the sense that you are not heard on an urgent basis, but subsequently you might succeed on the merits of the application. That happens too. Okay. So the court can say that the matter is not urgent, and then you decide to proceed with the application anyway, and then at the end of the day you go and win the application on the merits, in the sense of you get the
normal course.
Yes,
after you've said it now.
Yeah, in the normal course, yeah. So apart from these two requirements that the court needs to consider in order to decide whether or not it hears the matter as a matter of urgency, the applicant must also take into account the convenience of the court when they place the matter on the roll. So an urgent application by its nature interferes with the role of the court, because it's not catered for, it's not, the court has had no input into it being put on its roll. So the applicant comes and says, I want this urgent application heard on Tuesday at 9 o'clock, and the registrar has to set it down. So a judge must hear it. So the judges who are on duty for urgent matters, they also have other matters to attend to. So they have to create space for this application. So that is why the applicant, when it comes to court, must also take into account that inconvenience that it causes. So if it might be urgent, but it might not be so urgent that you come to court on 1 hour's notice. When would the court have had an opportunity to read the application or the answering papers or whatever? So that is what they talk about, what is meant with the convenience of the court. It is also linked with the other part of it, which says that once you realize that you need to come to court for relief, you have to do so as soon as possible after you've realized that you need to come to court. So you mustn't delay and then want to come and push the matter on the roll on very short notice. So if the issue that gave rise to the urgent application happened 2 weeks ago, if you come to court now a day you file the papers a day before you want to be in court, you're obviously not taking into account the convenience of the court and the other party, obviously, as well. You're actually prejudicing the other party in the process. So this case, the Luna meubelvervaardigers case, actually gives you a very good idea to determine the degree of urgency with which an application is to be brought. It actually gives a very good guideline for beginners, because the rules don't really tell you how to do it. And this is very helpful in the sense, in determining whether the person should have come at 9 o'clock on a court day, or whether the person could have come at another time, or on a day which is not a court day. Practitioners should carefully analyze the facts of each case to determine, for the purposes of setting the case down for hearing, whether a greater or lesser degree of relaxation of the rules and the ordinary practice of the court is required. The degree of relaxation should not be greater than the exigency of the case demands. It must be commensurate therewith. Mere lip service to the requirements of Rule 612B, that's under the old rules. Applications used to be dealt with under Rule 6, and 12 was the rule for urgency, will not do, and an applicant must make out a case in the founding affidavit to justify the particular extent of the departure from the norm which is involved in the time and day for which the matter is set down. So, what you have to do literally is to say in your affidavit, by telling what has happened, etc., you need to explain to the court why you need to be in court on Tuesday at midnight, as opposed to Wednesday at 9 o'clock. What is going to happen between 12 o'clock and 9 o'clock, basically, which will result in you not being able to be afforded substantial redress in a hearing in due course, or which makes the matter so urgent that it has to be heard at 12 o'clock. So that just illustrates to you how the applicant should approach his affidavit in satisfying the court that the matter is urgent. So this is how you look at it as an applicant. You obviously also don't want to prejudice the respondent, that you want to give the respondent as much time to deal with your application. So not all matters are equally urgent. So they don't all require to be in court within a day or 2 or 3. Okay. So that is what you have to show the court. But why could you not have served 2 weeks ago? Why could you not have served a week ago? Why could you not have served a month ago? That's also, there are also those kinds of urgent matters. So they refer to them as semi-urgent matters. And I know there's a case here in our courts where the court said that there's no such thing as semi-urgent matters in on our rules, but it's not really that there isn't. It simply means that this matter is not as urgent as the next one. So when you bring an ordinary application, that the other party has 5 days to oppose, then another 14 days to file their answering papers, and you then have 14 days to reply. That's the normal process. Then you must first go through case management, and then you will get a hearing date. So from the time that you've served the application to the time that you will be in court, it could easily be 6 months to a year, depending on the role of the court. So now compare that to being in court in 2 weeks from the time that you have served your application, or a month from the time that you have served the application. Like I think that, is it the Petrofund case or the other one, those cases were basically on a month's notice, I think. So it's all about how urgently you need to be in the court. So with an urgent application, It's not the registrar who determines when the matter must be heard. It's the applicant who determines. It's also the applicant who determines who must file when. They set out the timelines in their notice of motion. So they basically change around the things that are in the rules. And that's why the rule says the person actually comes to court and asks the court to dispense with the forms. The reference to the forms is the form provided for in the rule, the normal notice of motion form, which makes provision for 5 days to oppose, 14 days to answer, and another 14 days to reply. With a review, the timelines are even longer. So you are dispensing with that form. The court can also dispense with service requirements, because normally when you initiate proceedings, you have to serve through the deputy sheriff. The matter might be so urgent that you don't serve through the deputy sheriff. You can fax, you can email, you can go and deliver. You must just show to the court that you have actually effected service. So, but you must explain why you cannot use the deputy sheriff to serve. So even if the applications are urgent, you could make arrangements with the deputy sheriff and say, please, I need this served in the next half hour. Otherwise, you must explain to the court why not. Why you didn't use the deputy sheriff to serve. And you could obviously say that I did call the deputy sheriff, he said he's not in town and there's no one at the office or whatever. It could be somebody that's sitting remotely. It depends on what the circumstances are. So when I say the applicant determines the timelines, in the notice of motion, the applicant will actually say, you must oppose within 1 day of service, and you must file your affidavit within 2 days, or they could give the date. And then I will reply within another day, and then we are in court within the next 7 days, yeah. So they determine the date also. They will call the registrar and say, I want an urgent application. I want to set it down for next week, Monday, at 9 o'clock. And then they determine the timeline. So they know that they're going to serve. So today is what, Friday. So they know they're going to serve the papers today at 5 o'clock, by 5 o'clock. Then they say to the respondent, you can serve your answering papers by 12 o'clock on Saturday. I will reply by 12 o'clock on Sunday, and then we are in court on Monday. They put those things in the notice of motion. So practically how it could happen if it's such short notice, even where there's a lawyer involved, is the lawyer comes to court and he says, no, it's unfair. If you look at the issues that are being raised here, it's not necessary for us to be here in court so quickly. I want more time. And the court will say, okay, fine, I'll give you more time. And the parties can also agree in the meantime. Say, for instance, it's a sale and execution that's supposed to happen. And the parties could also agree or give each other undertaking and say, okay, fine, I'll postpone the sale and execution until next week. Then we can finalize this urgent application. Or if... it could be another example of something which you're coming to court to stop the person from doing something, and that person can say, it's fine, I won't do it now. I will hold back until this urgent application is finalized. And then they can agree on more flexible timelines. The urgent application might still proceed on those flexible timelines. When the court hears this application still, it will still consider the urgency issue. Yeah. So they might, as opposed to two, like say 5 hours at the time for each to file their papers, they might agree on, okay, give me a day, I'll file my papers, and then you have another day and you file, and then we hear the urgent application after that, and then the court will still consider, is the matter urgent? And if it still says it's not urgent, then it can strike it for lack of urgency. A strike that could go violent, that is going violent. I know of a case where I was involved. Unfortunately, I don't like doing war stories, but unfortunately those are better for me to remember, easier for me to remember. The employees went on a strike at a mine, and we brought the application and we had it heard on a Friday night. So there was no, we did serve, but we were there. I don't think the employees were represented. But we had that the urgent application was heard on a Friday night. The order was served on them, and the court ordered, gave a rule nice, I believe, and the respondents obviously could come back to court on another day to come and put their case before the court. And the court then had to decide whether that order will stand as a final order or whether it will then be discharged. So that is an example, so a strike, for instance. Or, so what sometimes happens is that the judge says, I just want to hear you on urgency. Then they hear you on urgency, and then they reserve their judgment. They come back to you 2 weeks later. Then they tell you, okay, the matter is urgent, I'm going to hear you now. And then it's really, the wind has been taken out of your sails totally. But the idea is for the judge to immediately make a ruling on urgency. And then to decide, am I going to continue with his merits or not? Some judges would say, if they sort of have in their mind, they might have an idea that this sounds urgent, but I'm not quite convinced. I want to first hear the parties. So they might say, I'll hear you on urgency and on the merits now, and then I'll give you my ruling in an hour, 2 hours, or tomorrow morning, or whatever. And then the court might come back and say, no, the matter is not urgent, and I'd strike it for lack of urgency. He has heard the merits, but he has not made a ruling on the merits. So you can still come back in the ordinary course. Or you might come back the next morning and say, yes, the matter is urgent, but you have not made out a case, and I dismiss your application. But then you have lost. All right, we'll take a break and then come back at 11 o'clock, man.